Welcome everyone. Today we will look at the ad Coelum doctrine that derives from a Latin maxim and has echoed through the courtrooms and has influenced and shaped the way we think about property rights for centuries. So let's unravel the nitty-gritty of this principle and understand how it impacts our understanding of ownership from the ground upwards, quite literally. This doctrine derives from the Latin maxim Cuius est solum, aius est asquat, coluem et ad inferos. In literal translation, it means to whoever it belongs, it is theirs up to the sky and down to the depths. That means, in the context of property law, it means that the owner of a piece of land has his rights extend above and below the surface of the property. Now friends, this maxim has two main components, ad coelum and ad inferos. Now first let's have a look at ad coelum. The ad coelum principle states that when a person has rights to a property, the title to the property also includes the rights to the space above the property. Now this was an easy interpretation until the invention of aeroplanes, which could fly above people's houses and hence their airspace. In the famous case of Heinman versus Pacific Air Transport, Mr. Heinman sued Pacific Air Transport for trespassing on his airspace above his property as they were flying less than 150 feet over his land. Now the court in this case rejected the application of the principle of ad coelum. The court said the air, like the sea, is by its nature incapable of private ownership, except insofar as one may actually use it. We own so much space above the ground as we can occupy or make use of in connection with the enjoyment of our land. The right is not fixed. It varies with our varying needs and is coextensive with them. The owner of land owns as much of the space above him as he uses, but only so long as he uses it. All that lies beyond belongs to the world. So, in this case, the court declined to apply the ad coelum doctrine and reasoned that the title to the property or the owner of the property has exclusive rights over the airspace above his property to the extent that it can be used by the owner. This principle of ad coelum was further clarified by the Supreme Court of the United States in the case of United States versus Causby in 1946. Here the court rejected the notion that property ownership extends upwards of the property indefinitely. This concept of where country sovereignty ends and space begins we can cover in another video on space law. But to summarize the ad coelum principle in today's world, we can say that property rights in airspace are not absolute and have to be balanced with the needs of air travel and other public interests. Now the maxim also has the other part, that is ad inferum. Now this refers to the center of the earth, but in legal jurisprudence, what it basically means is that the ownership rights are limited as regards the space immediately below the property. It is this space that can reasonably be used by the owner. In fact, the deeper the region beneath the property, the more likely the courts would not allow the holder of property any rights over it. This is because the owner would not be able to make use of that space, and therefore any project or underground work like laying of pipes, etc., which is made reasonably below the property will not violate the holder of the property of any rights. And friends, in today's world, where skyscrapers are the norm, especially in big cities, air rights are determined based on local zoning laws. Every property has some amount of air rights, but not absolute. And the extent of these rights vary depending upon the city, location, and of course the zoning laws of that particular area. And that is the specific reason as to why some areas allow skyscrapers to be built whereas there are certain residential areas where skyscrapers are not allowed at all, even though people might have air rights, because these things are not allowed as per the zoning laws of that particular area. And friends, to conclude, the ad coelum doctrine is accepted in a limited form in property law. That is, owners of a property have rights over the air immediately above and the land immediately below their property, so long as they are making use of it. So friends, I hope you liked the video. Please do share, like and subscribe to my channel, and I'll see you soon with another video. Till then, goodbye, take care, and have a wonderful day.